In this video, we're going to examine the legal theories of negligence and strict liability. Negligence is referring to medical malpractice. When you hear that word, as we'll discuss in a later slide, negligence is what we're talking about when we say medical malpractice. Medical malpractice simply refers to negligence that occurs in a professional setting, and the setting here for medical malpractice is the healthcare field. And so this video is really an overview of the doctrines of negligence and strict liability so that you can better understand these, because this is the foundation, negligence at least is the foundation that a lot of the book will cover and talk about in relation to malpractice. And you will see throughout not only the tort chapter, but other chapters where there's going to be plenty of examples of negligence. You'll see cases talking about ways in which a nurse was negligent, how they failed to do something, how a dentist failed to do something, how a doctor failed to do something. And so you're going to see a lot of examples of what a duty is, such as a duty that you have to treat emergency patients. And not only do you have the duty to timely care for them, but you have a duty to also stabilize them. You have a duty to hire competent medical professionals. You have a duty to prescribe the right medicine. You have a duty to order diagnostic testing. You'll see plenty of examples of the different types of duties and when there's a breach of the duty throughout later chapters. Negligence, as you recall, we distinguish negligence and intentional torts in the intentional torts slideshow. But just as a reminder, the main difference is that negligence does not require intent. And the intentional tort requires that you have the intent, not necessarily to have the exact harm or the exact consequence that happens, but you have to have had some intent to cause the act, knowing that there could be consequences for that act. Negligence, on the other hand, you're not looking for that intent. In fact, a lot of times the intent is missing. Rather, what you're looking at is the reasonableness of the defendant's conduct. To give negligence a definition, negligence is the defendant's failure to act as a reasonably prudent person would under similar circumstances. And it's important to note that negligence can result from either an act that's taken or a failure to act. So an omission of action could be a basis to establish negligence. Thus, in negligence, the defendant does not have to intend or know that his action could cause an harm. Rather, we're looking at whether what the defendant did failed to be along the standard of what a reasonably prudent person would have done in the. So a plaintiff must prove 4 elements in order to recover on a negligence basis. These 4 elements are 1, duty, 2, breach of that duty, 3, causation, and 4, damages. So when we say duty, we'll examine all these in more depth in a moment, but just briefly, a duty is the defendant must owe the plaintiff a duty. That means that the the defendant must conform to some standard of care. There's an expectation of how the defendant should act towards the plaintiff. Then the breach is where the defendant's conduct fell below that standard of care, where the defendant did not act in accordance with the way they were supposed to. Damages, that's the easy one of when you have an injury to either the person or their property. And the causation element links the damages with the breach of the duty. And so you've got to have the causal connection that ties the wrongful conduct to the actual injury or loss that the plaintiff suffers. So duty, let's initially look at element 1, duty. A duty arises when there's a relationship between the defendant and the plaintiff that requires the defendant to act in a certain manner towards the plaintiff. So there's an expectation of how the defendant should act towards the plaintiff. The easiest example in the business context is we can talk about a storefront, a retail operation, and guests that come to shop there. Obviously, you have a duty as a business owner to provide a safe premises to people who come on your property. That would be the duty to provide a safe property, a safe environment for them to be in. So if you have a store, you've got to protect against a hole being in the floor or in the parking lot to where a plaintiff could be walking, a customer could be walking and they could not see it, they could hit it and fall and break an arm, drop a child, whatever. There could be harm that could arise from that hole. So you would have a duty to make sure that your premises is safe, whether you repair that hole or you protect through warning them of it. You would have to undertake some action in order to protect the customer to your store. So in that scenario, you would have a duty to do that. So if there's a duty, then you're required to act reasonably under the circumstances and avoid that harm to the plaintiff. So the action here in the scenario we just gave as the store owner is to fix the hole in the floor. And by fixing the hole in the floor, you're avoiding the harm that could happen to the plaintiff, to the customer, because of that hole. The standard of care that we talk about is an objective one. And by saying it's an objective standard, we mean that you look at what a reasonable person of ordinary prudence would do under the circumstances. You don't put yourself in the position of that defendant. You don't put yourself in the shoes of this one business or this one person. Rather, you put yourself in the shoes of what the ordinary and reasonable person would have done under the circumstances. You know, if you want to think of it in generic terms, it's what would the majority do in this situation? Faced with these circumstances, what would a reasonable person, what would have been the normal reaction? So that's where you're looking at an objective standard rather than the subjective nature of this specific defendant. So whether a defendant owes a duty to the plaintiff, that's a question of law for the court to decide. So that's not necessarily something that the parties decide or the jury will decide. Rather, it's a determination made by the court, because if there is no duty, then there is no negligence claim. So it's a question of law that the court decides. So we have an example here, and that ties in with the example that we just talked about, where businesses have a duty to warn or protect against foreseeable risks of harm. Similar example is where drivers, if you're driving a vehicle on the road, you have a duty to exercise reasonable care when you're operating that vehicle to avoid injury to either a pedestrian or another driver. So the second element, let's start looking at the breach. So we've talked about what is the duty and how is it defined, and it's where you have an obligation to conform to some expectations of how a reasonable person would react under those circumstances. So the breach is very easy in that that's where you failed to comply with what's expected of you. So once you define what the duty is, what the expected standard of care is, then you have to analyze whether the defendant actually breached that duty. In other words, did the defendant actually deviate from the standard of care? Is what they did considered a violation of what was expected of them? Again, this goes back to the objective standard of the standard of care is what the standard of a reasonably prudent person under similar circumstances would have done. And so if the defendant's actions are different than that, or they deviate from that, then there may be a breach of the duty. For specialty areas, and we'll talk about this in just a little bit later, we'll talk about professional malpractice. For specialty areas, the defendant's going to be held to how a reasonable person in that industry would act. So a lawyer is going to be held to how a reasonable lawyer would act, not how just a reasonable common person would act. Negligence per se, this is a doctrine that comes in and it's a form of ordinary negligence. It just helps you establish what the standard of care is and helps you know whether it was violated. And so sometimes in this doctrine, you can have a statute or a regulation that may define what the expected conduct by the defendant is. Um, the statute and regulations, if there's a statute that's on it, it's not automatic that it's going to be a statute or a regulation that defines how the defendant should act or what their conduct should have looked like. In order for a statute to do that or regulation, the statute has to be specific in defining what standard the defendant is expected to follow. So if it's just the statute talks in general terms, that's not going to be enough. Also, if the statute talks in terms of how an ordinary and reasonable person would act, then that's really not defining any standard because that's what you would expect under the ordinary duty analysis. So a negligence per se has to be where the statute clearly defines some conduct. As an example, if you have a statute that says that in a certain situation the defendant must do X, Y, and Z, that may define the standard of care that the defendant has to exercise. So in a banking situation, there's a statute in Tennessee that says a bank must, when it's making a payment, and we've talked about this example before, but when a bank is making a payment in a construction loan context, the bank has to make the check payable to both the borrower and the builder. And in that scenario, there's an argument that that statute defines the bank's conduct. It defines the standard of care that the bank has to comply with. And if the bank fails to make the check payable to both the builder and the borrower, then they have arguably violated the standard of care. So that would be a statute that may be specific enough to define the standard of care. But in Tennessee, there are a number of statutes that define the rules of the road, and they define expectations of how a driver should act. And some of those are in the very general terms of how you would expect a reasonably prudent person to act while driving a car. Those statutes do not, likely they do not define a specific enough standard of care such that they would be able to establish negligence per se. So if you have a statute that says that a driver must use due care in operating the car or in switching lanes, that expectation is there under the objective reasonable person standard that we've talked about. So that statute is not going to be specific enough in defining the conduct that's expected of the defendant. So those statutes on the rules of the road are most likely not sufficient to establish a standard through the process of negligence per se. So you would go back to the standard of a reasonable person. How would the reasonable person act in that under those circumstances, as opposed to the statute says that the defendant must have acted this way when operating his car. So causation, determining whether there's a duty and determining causation. Those are usually the two hardest analysis or two hardest elements of a negligence claim. So causation, so once that you have a breach of the duty or an alleged breach of the duty, because that's a decision that's made by the fact finder, just like causation is, then the plaintiff must establish that the alleged breach is what caused the plaintiff's injuries. So you've got to have that link between what the breach was and what the injuries are. You can't just have, well, somebody breached conduct, they had conduct that breached the standard of care, um, but it didn't really cause any injuries, but I do have other injuries for another reason. So the book gives a good example in that scenario of where you have a person who put the trash out and the lady was running and got hurt and fell, but it was because she tripped her ankle rather than hitting the trash can. And so her injuries were caused by her rolling her ankle, not by anything with the trash can and the conduct of the defendant. So there you would lack that causal connection because whether the garbage can was there or not, she would have still suffered her injuries. So in causation, there are two types of causation. You've got to have actual cause and you've got to have proximate cause. And courts will look at these um, and you may meet one, but you may not have proximate cause. And if you don't have proximate cause, you're not going to have a successful claim. You've got to have both actual cause and proximate cause. Only having one is not enough. It's also important to note that proximate cause you may see in the book or in somewhere else where they refer to something as legal cause. Legal cause is another name used to refer to proximate cause. Proximate cause and legal cause mean the same thing. So actual cause, this is what's known as but-for causation. So the idea is that the plaintiff has to prove that but for the defendant's conduct falling below the standard of care, so but for the defendant's breach, the plaintiff would not have suffered the injury. So you've got to show that because of their conduct, I suffered the injury. So if the plaintiff would have suffered the injury even in the absence of the defendant's conduct, then there's no actual cause. So the example that we just talked about goes right to the actual cause, where you have a lack of but-for causation because in the absence of that defendant putting the trash can there, the injury was still going to happen because she rolled her ankle and had nothing to do with the placement of the trash can. Actual cause can become very interesting when you have multiple defendants. When you have multiple defendants, it's hard to say but for because it may have been conduct by several people that establishes that causation. And so since you can't necessarily get to but for, then you substitute in where the conduct by the defendant has to be a, quote, substantial factor, close quote, in causing the injury. So it's not in the but for analysis, it's the sole reasoning in the multiple defendant analysis, it's just got to be a substantial factor. So it has to substantially contributed to causing the plaintiff's injury. With multiple defendants, it's also possible that it can be difficult to establish who the cause of the injury was. The book gives the example of where you have two hunters and they both shot at a bird, and if it hits somebody, then you don't know whose shot was fired is the one that caused the injury. In that scenario, the court will put the burden on the defendants and say, well, you establish who it was. And if you can't establish who the person was that caused the injury, then the defendants are both going to be held liable. Proximate cause. This is where the plaintiff has to show that the defendant actually had a duty to protect the plaintiff from the specific conduct that injured him or her. So this is where the law tries to place some limits on the defendant's liability, place some sort of a limit on how far out, how foreseeable the conduct has to be. So the limit is that you only are liable for protecting the plaintiff from harm that was reasonably foreseeable. So it goes right back to what we've talked about. Everything is about this reasonable foreseeability. And so it places some sort of constraint or limit on the defendant's liability. The defendant's not liable for every possible harm that could have occurred. This is very well demonstrated through the Paul's Graph case. Paul's Graph case is a very important case in legal theory on proximate cause, and it's the case that's studied probably every tort class across the country in law school. And proximate cause in that case was defined by the concept of a zone of danger. So that's what you can think of is that it places a circle around the possible liability and says if it's in this circle, then it's something that the defendant can be liable for, because in the circle is conduct that's reasonably foreseeable. But anything that happens outside of that circle is not reasonably foreseeable. It's unforeseeable, and therefore it's not something that the defendant would be liable for. In other words, there would be no proximate cause for any of the conduct that is outside of the circle. The conduct inside that circle, that zone of danger, is conduct that the defendant could be liable for. There would be proximate cause for that conduct that's in the zone of danger in that circle. So the Palsgraf case is a great example. So in that case, you have the plaintiff who is standing. It's at a railroad station. It's out as someone is getting on a train. The plaintiff is standing over near the building, and there are some scales that are hanging on the wall or from the roof. I'm not sure, but there are some scales that are hanging near where the plaintiff is standing, and away from the plaintiff, not where she's at, but quite a ways from her, is a gentleman. I believe it's a gentleman, but someone is getting on the train as a passenger, and they have a wrapped box that has fireworks in it. As the person's getting on the train, that box is dropped and it hits the ground, causing the fireworks to go off. And as a result of the fireworks going off, the scales fell down and hit the plaintiff, and the plaintiff sues over it. The court came up with the zone of danger theory. They found that the likelihood of the scales falling and hitting her were outside the zone of danger in the Palsgraf case, and so they didn't see it as it was not foreseeable that a person would get on, have fireworks, the fireworks would go off and cause the scales to fall off and strike the plaintiff. They found that causal connection to get there was too remote. There was too much between it. So you lacked proximate cause in that scenario. So for there to be proximate cause, it's got to be an injury that's foreseeable, and that is in the terms of it's something that's within the zone of danger. It's specific conduct that was foreseeable, such that the defendant had a duty to protect against that specific conduct. Res ipsa loquitur. This is similar to like negligence per se. It's a part of, it's not a separate doctrine, but it helps aid a plaintiff in proving his or her negligence claim. So res ipsa loquitur, it translates into the thing speaks for itself. So it's a doctrine that helps the plaintiff prove the breach of the duty and the causation element when breach and causation is unknown. So typically these scenarios, there's an accident that's happened, and the accident's a type that would not have occurred without someone having been negligent. And so when we say that they can't prove it, it's because there is no direct evidence of what happened. No one saw exactly what happened. So these claims require that the plaintiff prove three things. One, the plaintiff has to prove that the incident was a type that generally does not happen with negligence. It was caused by an instrumentality that was solely in the defendant's control. And three, the plaintiff did not contribute to the cause. So an example would be if you have the plaintiff is standing outside of a business, and from the second floor of the business, say a small barrel that's holding, say, 5 gallons of a drink, rolls out the window and falls and strikes the plaintiff in the head. Well, the plaintiff didn't see what happened. The plaintiff and no one else may know what happened. And that's a scenario in which the plaintiff may rely upon the res ipsa loquitur doctrine to prove negligence against the defendant, the store. This is a type incident that doesn't happen without negligence by somebody. Barrels of a drink don't normally fall out of windows of businesses. So that's something that generally wouldn't happen without negligence. The thing that caused the negligence, the instrumentality, was solely in the defendant's control. That barrel on the second floor of a business is likely in the control of the defendant. And then it's obviously something that the plaintiff did not contribute to cause. The plaintiff didn't have a hand in causing the barrel to roll out of the window and strike him or her on the head. Most commonly, when you do have the res ipsa loquitur doctrine that applies, it usually allows there to be a presumption that's rebuttable of negligence. So if you establish that it applies, then generally negligence is presumed, subject to the defendant then rebutting that they were negligent. So the last element here is injury. Injury is pretty simple in that there must be some injury to either the person or the property. If there is no harm that's caused by the defendant's negligence, by their breach of their duty, then the plaintiff cannot recover. Without any damages, then there is no basis to prevail on a negligence claim. So we've had several of these cases that I've been involved in where maybe there was a technical breach, but there were no damages from from any technical breach. Um, an example I can go back to is we've talked about the bank scenario where the statute obligates a bank in a construction loan to make the construction payments on a check that's payable to both the borrower and the builder. In that scenario, the case that I was involved in where that became an issue, there were no damages because the bank did not know of that statute, and the bank did not make the checks payable to both the builder and the borrower. The bank just made the check payable to the builder. In that scenario, they arguably violated that statute, violated their duty, but there was no damages that the defendant, that the plaintiff, the borrower suffered because her name wasn't on the check. And so since they couldn't establish any damages that was caused by the mere technical breach of the statute, their negligence per se claim failed. Professional negligence, this is a slide a little bit ago that I said that we would come to when we talked about the breach of the duties. So negligence by a professional is known as malpractice. So you've probably heard of medical malpractice. That's the term that's given to negligence by doctors, by physicians. And so that's simply what we've talked about of you have the negligence, you have to have a duty, a breach of that duty, causation, and injuries. But the standard that you're held to is different because who you owe a duty to is different as well. But the standard is that you're held not to that reasonable person, general reasonable person, but you're held to a reasonable doctor standard. Or if you're talking about in the context of a lawyer, you're held to how a reasonable lawyer would have acted under those circumstances, not how a reasonable common man or woman would have acted under those circumstances. Also, in these professional negligence cases, these malpractice cases, to whom a duty is owed is much more limited. Usually, you're limited to who the patient is or the client is. Professionals include doctors, lawyers, accountants. The doctor, the lawyer, the accountant, they're required to exercise the same degree of care that a reasonably prudent professional, another lawyer, doctor, or accountant would have exercised under the circumstances. If you fail to do that, then it's more than likely professional negligence. To conclude this chapter, or this video, let's talk about respondeat superior. That is the legal term of art that basically means that an employer is being held liable for the negligent acts committed by an employee in the course and scope of that employee's employment. So it may be that the organization, the employer itself, is not doing the wrong, but rather their employee is doing the wrong. And because they're acting in the course of their employment, the employer will be held liable for the negligent acts of its employee. And liability is imposed even if the employer does not know that the employee has committed these wrongful acts, or if the employer has not directed the employee to commit the wrongful act. It can all be done by the employee with no knowledge of any supervisor or management employee, and it would still bind the employer to liability. And so let's take an example of a retail store. You have a retail store and you have an employee who is carrying a bucket of water and spills water on the floor and fails to clean it up and fails to put any sort of sign out there to warn customers to be careful that there's a wet floor. Someone comes along, they hit the water, they don't see it, they fall, they break a wrist. In that case, it was the employee who was negligent. Because the employee was in the course and scope of his duty, the doctrine of respondeat superior would hold the employer liable for that employee's negligent act of spilling the water. So now that we've talked about negligence, let's talk about strict liability. So in negligence, if you compare and contrast the two, in negligence, we've been talking about, well, how did the defendant act? Were they reasonable in how they acted? Did they do what you would have expected a reasonably prudent person to have done under the circumstances? That analysis is irrelevant in a strict liability context. So strict liability is just like you would expect. It's strictly imposes liability regardless of the defendant's actions. So liability exists without any fault, without any intent. The defendant could have done every single thing possible to avoid any injury or harm. And if they did everything that they could have, it still doesn't matter. They're going to be liable for any injuries. Strict liability applies in two contexts: products liability cases, which we talk about and analyze in the next video, and ultra-hazardous activities. Ultra-hazardous activities are those activities that are abnormally dangerous. So if an act is considered ultra-hazardous, then there's strict liability, and the defendant's going to be responsible for any injury that occurs, regardless of how careful the defendant is. So for an activity to be ultra-hazardous, the activity has to involve a risk of serious harm to persons or property that cannot be eliminated through the exercise of due care. So it's a risk that even if you take all the steps possible, you still can't eliminate that risk of harm that exists. And the second requirement is that the activity is not a matter of common usage. So it's these ultra hazardous activities are ones that don't happen on an ordinary or routine basis. So strict liability has been imposed in these 7 type cases. So one was a case in which they were storing high quantities of flammable liquids in urban areas. Another strict liability was pile driving, rock blasting, crop dusting, building a roof that allows snow to fall into the highway, locating oil wells or refineries in populated areas, and housing wild animals or domestic animals that are known to have a propensity to be violent. So these are examples in which courts have found there to be strict liability because these are ultra hazardous activities. If you're engaging in one of these activities or something else that could be classified as ultra hazardous, then there's going to be strict liability, regardless of what efforts you take to protect or warn against the harm. But strict liability has not been found to include parachuting, drunk driving, maintaining power lines, and discharging fireworks. Those are things that discharging fireworks, you can be extremely careful and protect against some of the risks of harm. Um, Parachuting, drunk driving, I don't think those meet the requirement that they not be something that's of common usage. Same on maintaining power lines. You've got to maintain power lines. Those are something of common usage. So once the court has classified the activity as ultra hazardous, the defendant's conduct becomes irrelevant. It doesn't matter the amount of care that the defendant used. Now, it becomes irrelevant in the sense of whether or not liability is imposed. But due care, so exercising proper care, doing what you can to prevent something, can be important on helping avoid punitive damages, which we'll talk about a little bit more in just a few slides. But punitive damages may not be, or less likely to be imposed if the defendant exercised conduct of reasonable care. They took steps to avoid harm, but unfortunately, because it's an ultra hazardous activity, they were unable to avoid that harm. In those scenarios, it's less likely that a jury would impose punitive damages on you because you tried to do everything you could to protect